of 6 webinars. My name is Cindy Dyer. I'm an attorney with the Texas Legal Services Center's Child Welfare Team, and with me I have Nicole Love, who's also an attorney. She's going to be monitoring the Q&A. You are welcome to ask questions along the way, and she'll answer what she can. When she answers those questions, those will show as public, so feel free to chat with her along the way. We're going to go ahead and get started. This is our first of 6 webinars that are going to be the third Wednesday of every month through August. These recordings will also be available on TLSC's platform for future viewing. Our focus with this webinar series is to provide legal information and education in a variety of subject areas that directly impact kinship caregivers in Texas. This webinar will explain non-parent custody options, recent changes to standing laws from this last Texas legislative session that might affect non-parent caregivers seeking custody, and then practical alternatives that exist in Texas law when custody is not possible, which includes both educational and medical authorizations that can help a non-parent caregiver meet a child's day-to-day needs without a court order. All right. And so a little bit about us. We're with TLSC, and again, Texas Legal Services Center is a statewide nonprofit organization. We provide advice, advocacy, and representation across the state. We have more than a dozen subject matter practice areas. On our child welfare team, there's 7 attorneys, including me, and 1 social worker. We provide legal information, education, advice, and representation. And we do that through 2 projects. We have the Family Helpline and the Kin Care Project. Contact information for each of these will be at the end of this presentation, and I'll get into a little more at that time about what these do. But basically, our Family Helpline is staffed by a team of all attorneys who answer the phone 9 to 6, Monday to Friday. We provide legal information around CPS cases, whether those are open or closed, or just questions about CPS. You're not affiliated with CPS, but all the attorneys who answer that phone have significant experience representing family in those cases. We do not have any income restrictions or other qualifications to get our legal information from the helpline, and anyone is welcome to call us, and we keep those calls anonymous. The Kin Care Project started in 2024, and we provide actual representation and advice to non-parent caregivers. We do that in a variety of legal issue areas, and CPS involvement is not required in order to qualify for that representation. Again, I'll have contact information and more information about eligibility at the close of this presentation. This is today's agenda. What we're planning on doing is going through, do I have custody? There's lots of confusion in Texas about what actually is custody. We're going to walk people through that, what legal parents are, and some tools that are often used in CPS cases that cause a lot of confusion about whether or not those are custody. The second thing we're going to talk about is, can you get custody? And by that, we're going over standing and parental presumptions. Both of those are required in Texas law in order to proceed with a custody suit as a non-parent. Both of those have had significant changes in the law from this last legislative session. We're going to walk through some of those changes. And then the third thing, which is kind of where we operate as far as the Kin Care Project, are other legal options instead of custody that are currently available to non-parent caregivers in Texas law. These are 3 different kinds of authorizations that can be used for medical and educational purposes for children in non-parent caregivers' care. We're going to walk through all those as well to how to find those forms and guides if that fits you. All right, so as far as our first section of do I have custody? Well, I just want to start here. Is there a signed court order naming you specifically as a conservator? If not, you probably do not have custody. So many people misunderstand what the legal significance is of whatever piece of paper they have and believe that they have way more rights, legal rights to a child than they do. We get these calls all the time on the helpline and at the Kin Care Project. And so we just want to spend a little time walking through what is not custody. Basic thing to understand is if you have a signed court order by a judge, not a draft of an order, not a proposal, but a signed court order naming you specifically as a conservator, that means custody in Texas. That is what conservatorship is. It's Texas's word for custody. Other states call custody guardianship, but not in Texas. Guardianship is typically for adults in Texas with some exceptions. Of note is that guardianship is also a specific court proceeding overseen by a judge. If you've never been to court, you likely don't have guardianship or conservatorship. As far as conservatorship, those can be agreed orders where a family makes an agreement about who has custody and submits it to a court, but a judge still needs to sign off on that for that to be an official court order giving somebody custody. As far as parent-child safety placements and safety plans listed here, these are CPS tools often used in out-of-court CPS cases. They have no legal significance once the CPS case is closed or the document expires. If a document can be rescinded by a parent without ever going to court, it's not custody. It's permission from somebody who has legal rights to the child. Again, the only way to get custody in Texas is a court order that can then only be modified by another court order. Placement through a CPS court case often causes much confusion. Anyone who's experienced that when CPS removes children from their parents' home, they also file a custody case and a termination case, and they place the children with somebody else to care for them during that case. That can be a relative or a family friend or a foster home. Unless that placement has independent conservatorship with respect to that child, they also do not have custody. They get authorizations through CPS in order to provide medical and educational care, but those are not independent legal rights to that child, unless that person is also named a conservator. The temporary authorizations we're going to talk about at the end of this presentation under Chapter 32, 34, and 35 of the Texas Family Code are also specifically not custody or conservatorship. Neither is a power of attorney or any other notarized document form that someone found online and signed in front of a notary. Cannot emphasize enough the requirement that a judge needs to sign a court order in order to give someone conservatorship in Texas. I'm going to give a brief understanding of Texas law. And again, this is just meant to be an overview, right, in this time that we have together today. Something of import to understand is both legal parents, right, have equal rights to a child when there is no court order. Each parent would have the rights and duties listed. If there's no court order, the physical possession, choosing the residence, moral and religious training, reasonable discipline, supporting the child and consenting to medical care, as well as who has possession of the child or who can visit or who pays child support. If there's no court order for any of that, it is equal rights by the legal parents. Absent a court order, neither parent has more rights than the other, including possession of or visitation with the child. If one parent doesn't do what the other parent wants, there is no way to force the other parent if there is no court order. Texas law does not give any automatic legal rights to non-parents absent a court order. Current Texas law, which again was changed significantly in 2025, presumes that parents are able to make best decisions for their own children absent a court order saying otherwise. Even if a child lives with a non-parent, until and unless that person gets a court order, you do not have independent legal rights to that child. Voluntary authorizations, whether those are signed in a CPS context or outside of a CPS case, are simply permission slips. They do not give custody to a caregiver. What we want people to understand is only a legal parent has rights to a child when there are no court orders. Determining the legal father of a child can be complex depending on the situation. In Texas, paternity is the legal identification of a child's father. And when paternity is established in Texas, the child's genetic father becomes the child's legal father with all of the rights and duties of a parent. Paternity can also be established by what's called legal presumption in Texas. That's when the parents are married, by filing an acknowledgement of paternity or by a court order. An acknowledgement of paternity is a legal form signed by a man and the child's mother that states under penalty of perjury that that man is the child's father. An acknowledgement of paternity is usually used when the parents aren't married but agree on the identity of the child's father. And when that completed acknowledgement of paternity is filed with the Texas Vital Statistics Unit, the genetic father becomes the child's legal father with all the rights and duties of a parent with certain exceptions. Fathers can also be adjudicated, which means the court has filed an order naming a man as the legal father. This usually requires a DNA test. DNA tests, paternity tests can be used in legal proceedings, but there's specific guidelines to make them admissible in court, which means not a 23andMe test. Unless a man falls into one of these categories, he's typically not the legal parent and therefore would not have the same rights or duties that a legal parent would have. By extension, unless the father is a legal parent, his parents are not legally grandparents until he does something to become a legal parent. Of course, we are not trying to discount the biological relationship. We are simply highlighting that might not be enough to establish legal rights to a child in Texas without a father first taking an additional step. A kinship caregiver is not a legal parent unless there is a court order. I didn't want to spend too much time on this, but this is just a breakdown of the different Texas laws that define the different kinds of fathers that I was just referencing. All right, so for the confusion around CPS, didn't that paper that CPS had me sign give me custody? To this, I'll just simply say, is CPS a judge? No. Is CPS a court? No. Does CPS itself have the ability to give anybody custody without going to court? No. They can file a court case, but they are not a judge, and they are not able on their own to decide who has custody. Only a judge can order custody. If CPS did not remove the child into their custody and sue the parents for custody and termination of parental rights, then likely whatever CPS case a non-parent caregiver was involved in did not give them custody. We do have 2 additional webinars as part of this 6-part series that is going to go much more in depth in CPS proceedings, both in and out of court, to explain those from a non-parent caregiver perspective. These are some documents that CPS often has non-parent caregivers and parents sign when they're involved in out-of-court cases, which are both investigations and family-based safety services cases. We're going to walk through each of these in this presentation today very briefly. But what I want to highlight from this screen is none of them are court orders and none of these give non-parent caregivers custody. There can be consequences for somebody not agreeing to a safety plan or parent-child safety placement or rescinding one after one is signed, but that simply means that CPS might elevate the case to court and ask a judge to sign an order, not that they themselves as CPS get to order a parent to do something. As far as safety plans and parent-child safety placements, I'll show you some samples in just a second, but these are often used, right? A safety plan they're supposed to be both voluntary for parents to sign. The safety plan cannot exceed 30 days unless there's a written extension. It cannot conflict with an existing court order unless all parties to that order agree. I want to highlight this. We have many non-parent caregivers contact us referencing a safety plan and thinking that they have custody from that. I cannot emphasize enough that that is not custody. A safety plan for CPS's own policy is never supposed to be used as a placement tool. It's supposed to be used only for supervision of parent-child contact for a limited period of time, or the relocation of a parent and a child together away from danger, not separating the child from the parent. A safety plan has no legal significance once a CPS case is closed or once it expires if it is not renewed. A parent-child safety placement, also not a court order, also voluntary, and also can be rescinded at any point. It cannot exceed 30 days, but it can be eligible for 2 extensions for a total of 90 days. It also cannot conflict with an existing court order unless all parties to that order agree. And it is also has no legal significance once a CPS case is closed. Both of those documents, for instance, if there are parents and there are existing custody order in places, and during the investigation, CPS is asking that the parent or parents sign a safety plan or a parent-child safety placement, denying a parent from their court-ordered possession, that parent would have to agree to that in order for this to work. A Chapter 34 voluntary authorization we're going to get to in our last section of this webinar today. That is a tool that is often used by CPS, but that survives, unless rescinded, a CPS case because it is a tool that is used outside and in different sections of the family code that do not just apply to CPS cases. Just wanted you to see this is what a safety plan looks like. This is straight from CPS's website. You can see on here on the face of this safety plan, the 2 purposes for which it should be used. And on the back of this safety plan, it says right here that this will no longer be in effect once CPS stops investigating or providing services to the family. This is what a parent-child safety placement looks like. Again, you can see on the face of it, it automatically terminates on the 30 days. After 30 days, and cannot be used more than 2 additional times. On the back of the parent-child safety placement, you can also see that it describes this as being entirely voluntary and citing the sections of the family code about how long it can last. So, what happens if an investigation or a family-based safety services case closes without CPS filing that court case, but the child is still left with a caregiver? This is specifically addressed in a CPS policy handbook in this section. This has become a relatively common situation that we continue to hear about at Texas Legal Services Center. And so I wanted just to highlight this policy. Oftentimes during CPS involvement, a parent agrees to place a child outside of the home with a friend or relative using a parent-child safety placement, and they agree to do that voluntarily for a limited time. At the end of CPS's investigation or a family-based safety services case, sometimes a parent might still choose to have the child live with the placement even though the CPS involvement is closing. Maybe they're between housing or they're in treatment or something else is going on, but they voluntarily agree to do it. It still means under CPS policy that the parent-child safety placement is ended anyway because it has no legal significance once the CPS case closes. The caregiver never got custody because CPS never elevated the case to court. So even though the caregiver agrees to allow the child to stay, that does not confer any legal rights. Sometimes CPS wants to leave the child in the PCSP's home, the placement's home, even though CPS is closing the case and ending all CPS involvement, because they as CPS do not think that the child is safe with the parent. In those circumstances, the caseworker, this is the second section on the screen, the caseworker tried to file the case in court, but either CPS's lawyer believes the grounds were not met legally, or they file the case and a judge denies it for failure to meet the legal grounds. In that situation, CPS closes the case and ends the PCSP because the case is closed. Even though the caregiver agrees to allow the child to stay, that doesn't give them legal rights either. With the legislature in Texas heightening the grounds in 2021 for CPS to remove children from their homes, many counties report 40 to 50% fewer removals since that time. So you've got a gap of cases where the legal grounds for removals aren't met. Legal grounds for removal are not being met, but the children are still with the relative and no one to assist with filing for custody. Again, we get a fair amount of these calls at TLSC. It is not enough that a child is in the caregiver's home under Texas law for that caregiver to request custody. That on its own is not enough. And that brings us to our second topic of, can I get custody? So, wanted to highlight standing, right? This is a legal term. Basically, it means the power or right of somebody to file a lawsuit. The Texas Family Code specifically provides who has standing to file a custody lawsuit. And again, custody is conservatorship in Texas. Those actual custody lawsuits are called SAPSers, or a suit affecting the parent-child relationship. And so in Texas, the law and the Family Code in Chapter 102 specifically lays out who's allowed to file a custody case. For instance, I, having no relationship to a child in your home, cannot just come and file a custody case, right? There are several sections that say who has standing, depending on the type of case, to file a custody case. Under this section, which is section 102.003, you can see here, Kinship Caregiver would have had standing to file a custody case under this section as the first, if they've been a placement in a CPS removal case for at least a year, that child still hasn't been returned to the parent and the case is still ongoing. Or you can see that a relative within 4 degrees of consanguinity can file an original case, custody case, but only if both parents are deceased. There are other sections we're going to get to, but I want to highlight this because this section of the Family Code has been changed a lot over the previous years to limit who has standing or to give more people standing. This is the current version in effect as of September of 2025. If somebody does not have standing to file the custody suit, they cannot file the custody suit. I think it's important to understand here that the Department of Family and Protective Services always has standing to file a suit. They must have the legal grounds to do so, but they have standing. Okay, this is additional standing for certain relatives in a separate section of the Family Code in the same chapter 102, but 102.004. A grandparent or another relative of the child within the 4th degree of consanguinity can file an original suit if either of the two things happens. The order requested is necessary because the child's present circumstances would significantly impair the child's physical health or emotional development, or both parents, right, or anyone else listed, filed the suit themselves and consented to allow the case to proceed on behalf of that relative. Another section I wanted to highlight, just because there's a lot of confusion around this, is Texas Family Code section 102.006. This is a specific section of the Family Code that only applies in lawsuits where CPS has filed a termination suit and terminated both parents' rights, and the children are in the permanent custody of CPS after that termination. There is a limited window within 90 days that a relative within the fourth degree of consanguinity can file a motion to modify custody. And again, it's a super specific period of time and a super specific case that must have been filed, a termination case by the department. Because there's so much confusion around consanguinity, it's defined in Texas Government Code, Chapter 573, but I also stole this chart. I did cite where I stole this from, so you can go look it up on this website. But I thought this was the best layout I had seen of consanguinity. And so the numbers to the left, I know it's a little hard to read on here, but that's why I listed the website, and you can go pull it up. The numbers to the left show the degree of consanguinity, and then the relationship is what's in the text. So if a non-parent caregiver is able to assess under those family code sections that they do have standing in order to file a custody suit or a SAPSR, the next hurdle they need to overcome is what's called the parental presumption, right? This is a big change to the law that happened in 2025, and it's effective as of September. I think before this change, this specific code section hadn't been amended since it was enacted in 1995, about 30 years ago. This is why, in my opinion, it's so important for people to stay current on the law. There's a lot of movement that's happening both in CPS law, but also in family law in the legislature, where things are being changed every couple of years in each session. And so someone, for instance, that could have maybe easily gotten custody in 2023 wouldn't now, just because of the changes of the law. It is going to be very difficult for a non-parent to get custody in a contested case against a parent under this new statutory framework. It's not impossible, but it's not what everyone is used to in this field. So in addition to standing, a non-parent caregiver who files a custody or a SAPSR case must overcome the parental presumption. Texas law does not put parents and non-parents on the same level playing field. The law favors parents. But the rebuttable presumption is it can be rebutted, right? So it's not impossible, but the legislature has made that a little bit harder this last session. And so this is the current version of overcoming the parental presumption. This is also in Texas Family Code 153.002. Now, a non-parent, in order to overcome that parental presumption, would need to show by clear and convincing evidence the following. Clear and convincing evidence is the standard of evidence that is used to terminate parental rights. So it's a higher standard of evidence. Typically, most family court findings and proceedings are being done by preponderance of evidence, which is just over 50%. So clear and convincing is much higher. The law also says now that if a judge makes these orders, right, and allows these suits to proceed, they can't just make a general finding saying it's in the best interest of the child for this non-parent to have custody. They need to state in the order the very specific facts, and they can't just use a catch-all. I also wanted to highlight modifications of existing orders. Right? This is why it's so important if a non-parent wishes to pursue custody that they first determine if there are already SAPSR orders in place. Parents honestly might not even know if they have custody orders in place because if they didn't start the court case, right, they might not even know. It's pretty common in Texas for child support to be requested through the Attorney General's office. And if that happens, typically that comes with custody and possession orders. So if an order already exists for custody, then it's not an original suit that's filed, it's a modification suit, which is a whole new lawsuit requesting a change to the existing custody order. Modifications also require standing, and they also require for non-parents that that presumption be rebutted. So if a parent, All right, so I just want to highlight the standing here. Any person who had standing under Chapter 102, which is what we just went over for original suits, if you've got standing for that, you can have standing to modify. The important piece is understanding this presumption. For instance, this second section of 156.008 that I have listed here, right? If a parent agreed, for instance, in a final order to get less custody, this is often what happens at the end of a CPS case. They agree, right? And a non-parent might have more custody than that parent. And then a modification is filed. That non-parent for that modification has to overcome the parental presumption still on that evidence. It's not enough to rely on what happened in the agreed order before. So in a suit between a parent and a non-parent, it is a rebuttable presumption that a parent acts in the best interest of the child and that it's in the best interest of the child to be in the care, custody, and control of a parent. All right. Also wanted to continue and just highlight a couple other things about new law. It's now required under this family code section that if a non-parent files this custody case, they have to include an affidavit at the time of filing that is sworn, right? And it details why denying their request would significantly impair the child. If that affidavit isn't included or doesn't stand to the level of the grounds it needs to, the court can deny that relief sought. One additional hurdle in this family code section, now a certified copy of the birth certificate is required with the filing. It's going to be filed under seal, right? But that birth certificate would establish the identity of the parents. I brought this up because paternal relatives who wish to pursue a non-parent custody case might have difficulty obtaining that birth certificate if the father hasn't been established as the legal father. Just wanted to highlight that one piece. All right, so in going through custody as it currently stands for non-parents in Texas, really wanted to spend some time on the true options that exist instead of custody. And this is a lot of where our Kin Care Project operates and a lot of what information the Family Helpline gives out over the phone, because there are options. They just aren't custody as people traditionally think of. So there's three kinds of legal tools, authorizations that currently exist in the family code already and have existed for a while. Those are under Chapter 34, 35, and 32, and we refer to those as a Chapter 34, 35, or 32 authorizations. Two of these can be done out of court entirely, and one is a limited court case that does not require full personal service on missing parents. We're going to go into each one of them specifically, and then I'll let you know how to both contact us if you need help and you're eligible, but also how to find those forms and guides on your own. The first thing we want to talk about is a Chapter 34 authorization. This is used for medical care, education, wellness, and identification. And this authorization allows a parent to delegate a non-parent to make these decisions for their child. That legal parent can give any or all, right? And again, I emphasize only a legal parent can give these rights to somebody or permissions to somebody. If you're not a legal parent, you don't get to give someone permission to do things if you don't have those rights for yourself. And so this is an entire list of anything that a parent can agree to let a non-parent do. And you can see this covers really a lot of the day-to-day care, right? Medical, dental, psychological, and surgical treatment, putting that child and enrolling them on health or auto insurance, enrollment in daycare or school, allowing that child to participate in extracurricular activities that require consent, allows permission for the child to get the learner's permit, driver's license, or state-issued ID card, to be employed, and to apply for and receive public benefits on behalf of the child. And a big one, again, is permission to obtain copies of state-issued ID documents. And to the extent allowed under federal law, the child's Social Security card. A Chapter 34 cannot give permission for a non-parent to consent for abortions, emergency contraception, or immunizations if a parent has said no. It also, those are explicit in the statute, those three. It also can't be used for an application for a child's passport, and that's because of federal law requirements to obtain a passport. This is what it looks like, right? Just wanted to highlight this. It's not a complicated form. People fill these out alone all the time. And again, I'm going to explain where you can find a guide that walks you through how to do this. What I did want to highlight is the family code specifically says that a child who's the subject of a Chapter 34 agreement is not considered to be placed in foster care. So this does not give custody to anyone, and it cannot be used to obtain the custody. These are for a term of 6 months, and they automatically renew for 6 months terms until terminated. They're signed before a notary. They can also be terminated at any time. A parent can at any time, and they don't have to wait the 6 months, and they can request the return of the child. Okay. I'm so sorry. Who can be authorized to be a caregiver? Any adult the parent chooses, right? As long as that person agrees. There are no background checks or anything else like that, unless CPS is involved in this authorization. If this is not in a CPS court case, if this is being used, there are no background checks or anything like that that are required. It comes with its own warnings and disclosures as well. It's always worth understanding those. I did want to highlight when a Chapter 34 cannot be signed, right? There's existing court orders for custody, child support, divorce, or pending, things like that, right? The court has to give permission for a parent to sign. If not, the agreement can be void or voidable. And this is because ultimately the court would have the authority over the child unless the parent has specifically been given permission to make certain decisions if there's an ongoing CPS case or things like that. So um, the other thing I wanted to highlight is that revocation just has to be in writing, but there's specific rules about how to do that. Our agency manages texaslawhelp.org. And that is where, as I'll show you at the end of this, there's specific guides that talk about how to revoke. Okay. Also of note, if the child is the subject of any pre-existing valid authorization agreement, if that has not been properly revoked yet, then you can't sign a new one. A few other warnings and disclosures, right? Again, it does not give temporary custody. It cannot order that the parent pay child support, right? It does state that the non-parent caregivers are required to pay some expenses for the child or can be liable for some expenses for the child. Um, Again, the guide that walks people through this can answer most of the questions. And if people are eligible for the Kin Care project, it is also something that we can assist with. The second kind of authorization is under Texas Family Code Chapter 32, and this is consent for medical treatment by a non-parent. So under the Texas Family Code, parents have the duty to provide a minor child with medical and dental care and the right to consent to a child's medical and dental care. Under this section of the Family Code, there are certain people who can consent to healthcare treatment of a child when a parent can't be contacted. And if that parent has not expressly told anyone, the treatment cannot be given. So it's a form. Again, there's a sample on Texas Law Help that can be completed and given to the medical provider when that parent can't be contacted, as long as they have not specifically denied that treatment. The code provides that these are the adults who can give that permission and consent: a grandparent, an adult brother or sister of the child, an adult aunt or uncle of the child, or an adult who has actual care, control, and possession and already has a written authorization. When can it not be used? If the parent has said to the non-parent caregiver that they do not agree with the consent, if the parent withdrew an authorization to consent, or if the parent expressly refused consent for immunizations. This is what it looks like. It's a two-page form. I just cribbed the first page, right? But includes the minor's name, name of one or both parents, name of the person giving consent and the relationship to the child, what type of medical treatment is to be given, and the date the treatment is to begin. Also, under Chapter 32 of the Family Code, specifically 32.003, certain children can give their own permission or consent to certain treatment. This is not an exclusive list, but these are just the ones relevant to this presentation. So if a child is 16 years or older and they live separate and apart from their parents or managing conservator with or without that parent's consent, and regardless of how long they've lived in this other residence, if they are managing their own financial affairs, then they can consent. And that does not mean they need to be emancipated. And there's nothing in there that says they need to be providing all of their own financial affairs or needs, right? It's not really that defined. If that circumstance is met, a child can consent to their own diagnosis and treatment of an infectious, contagious, or communicable disease. If they are unmarried and pregnant, they can consent to hospital, medical, or surgical treatment other than abortion. And they can also consent to examination and treatment for drug or chemical addiction. A few things to know about a child giving their own consent. If they're eligible under that code section, adult permission is not also necessary. Some doctors' offices or front desk personnel might not know or understand that. And so sometimes it might be helpful just to have a copy of this law. A lot of hospitals already have a policy in place and print it out for their personnel to make things easier, but many places don't. Specifically, I've noticed a child can consent to their own counseling in any of the following circumstances unless there's a court order that says otherwise. An adult who does not consent is not responsible for payment of the child if the child's the one consenting. And finally, we wanted to explain Chapter 35. Authorization. This is a temporary authorization for care of a minor child. This is actually filed in court. The reason I don't call it a lawsuit and just a petition is because the service requirements are different than a lawsuit. Right? The use for this is when a parent cannot be located or doesn't respond, right? So this is not the full on, it's the same as a full on lawsuit that requires personal service of the parent. What this tool does, again, we have samples on Texas Law Help. These are the specific family code sections that apply. Basically, what it exists for is when no parent, conservator, or guardian is available to consent. So if they're not available, they can't sign a Chapter 34 agreement allowing for this. And so when a caregiver, this is for when a caregiver is in need of a court order that gives them the right to do things such as consent to medical treatment, obtain public benefits, enroll children in school or daycare, authorize extracurricular activities, or authorize other care that is essential to the child's welfare. Basically, what a Chapter 34 does when a parent agrees to it is a little bit different than in a Chapter 35 when a non-parent caregiver is going to court to get a judge's order to allow that. This needs to be sent by certified mail. It can be personally served, right? But it can also just be sent by certified mail, return receipt requested with a copy of the petition and a notice of the hearing to the last known address of the parent, conservator, or guardian. Basically, a court then sets it for a hearing and they hear evidence on the child's need for care. If a parent does show up and objects, the petition shall be dismissed. This is not a contested custody case, and that's not the purpose of it, right? So if a parent does surface and objects in court, then the petition shall be dismissed. This is no longer the proper vehicle or venue for this kind of temporary authorization. The court shall grant the petition and the orders only if it finds by a preponderance of the evidence that the child does not have a parent, conservator, guardian, or other legal representation available to give the consent. These orders, if signed, expire on the first anniversary unless the court determines an earlier date. They can also be renewed by a court for a period, but only for one additional year. And that's if the petition shows a continuing need. And at any time, the petitioner, the parent, the conservator can ask to terminate, and the court shall do so on a finding that there is no longer a need. So who can be a petitioner in a Chapter 35 case? A grandparent, an adult sibling, an adult aunt or uncle, or an adult who has a written authorization for care. What this section does is says those who can do this, it ties it to who can also do a Chapter 32 or a Chapter 34. Other requirements, that child needs to have lived with the person who's filing this for at least 30 days before the petition is filed. And good news, it's not a lengthy period of time. And the caregiver doesn't need any other signed written documentation that enables them to provide the care to the child before they file this. Again, here's the list of what can be ordered. Again, the court cannot authorize a passport application. The rest of this can be ordered. It can be all or some. Of note, and again, the theme of these authorizations in the code, this is not custody and it does not confer standing to somebody to get custody. And this is specific in Family Code Section 35.007. It does not affect the rights of a child's parent or conservator. It does not establish legal custody, and it does not confer or affect standing or a right to intervention. And it's not a child custody determination and does not create a court of continuing exclusive jurisdiction. And so we're very grateful to have tools like this in place. All of these authorizations that allow non-parent caregivers to provide care in certain ways to the children that they need. We just want to highlight, as we have throughout this presentation, that it's really specific in the code, right? That these are not custody or conservatorship. So what I kind of wanted to end on today is just the resources that are available for non-parent caregivers in this area. We have the KinCare project, and this is what we focus on. There are some more legal issues, but a big bulk of what the staff attorneys work on is listed here. Custody or custody changes, as in modifications, we only assist if those are agreed, unopposed, or default, right? We do not assist with contested custody matters. We are not taking cases to fight parents on those situations. We are here for agreed issues in custody cases if needed. A big piece of what we can do is talk people through if they qualify for medical or educational authorizations as a non-parent caregiver, and if so, we can help those be created. Obtaining public benefits for the caregiver or the children, including Social Security issues, getting identification or documents for a child in a non-parent caregiver's care. All of those are things that people are welcome to apply for. Our eligibility requirements, our grant funding right now, the household income of the applicant cannot be higher than 200% of the federal poverty guidelines. We are very grateful to our funders, and unfortunately at this time, we do not have the flexibility to go above 200% of the federal poverty guidelines. There's no way for us to qualify someone for that. So please just keep that in mind. If you apply and you're well over that, we're not going to be able to assist, even with advice. There's no requirement for CPS involvement to apply to our services. Our staff attorneys have helped plenty of non-parent caregivers who do not have or have not had CPS involvement. You have to be a non-parent caregiver to apply. You can either email, right? And then our social worker will reach out, or you can call and leave us a voicemail and we'll do the same thing. Our services on the KinCare project require an actual intake. We have to run conflict checks and qualify income information. And then after that is done, that person with us is eligible for assistance. We also have the family helpline that I referenced. And what the family helpline is that's staffed entirely by lawyers who have experience in CPS cases. We provide legal information only, which means we can't give you advice and we don't represent anyone on this helpline right now. We can do a lot with legal information. There's mass confusion around in and out of court CPS cases, how to make a report, child safety, things like that, understanding non-parent caregivers and the intersection of the CPS world. We can answer lots of those questions. Again, these calls are anonymous. We collect a little bit of demographic information that's voluntary, and we only collect a first name, which can be a pseudonym. We really want people to feel comfortable answering or asking whatever questions they have. If someone calls that helpline and they don't have any questions about a CPS case at all or CPS questions, they will be screened out. I know the name is the family helpline. We do not answer regular family law questions unless there's a CPS element to it. So I want to be candid about that up front. If you call us during these business hours and we don't pick up, we're just talking to other people, we try to give everyone a call back within one business day. And finally, the third resource I wanted to let you all know about is the texaslawhelp.org, which is managed by Texas Legal Services Center. On here, plenty of guides and information for people who are trying to navigate a legal world without access to a lawyer. Wanted to highlight specifically a few things: the non-parent caregiver authorizations and the consent to medical treatment, so the 32, 34, and 35, all have sample forms on texaslawhelp.org and all have guides that explain how to fill those out and complete those. We also have we released this in the fall, Navigating Kinship Care in Texas, a guide to non-parent caregivers' rights and resources that walks through a lot of what we talked about today, but also has additional resources that might be helpful. All right, everyone, that concludes our presentation.